A very good afternoon to all of you. I am Nancy Garg, your host for today's webinar. I welcome you all to this webinar session scheduled today. We have a very special guest with us for this webinar. I welcome our guest speaker, Justice Subodh Shah, retired Judge, Gujarat High Court. Thank you so much, sir, for accepting our invitation and joining us today for enlightening the budding lawyers and young minds connected with us here. Before starting the webinar, I would like to introduce our guest speaker. Sir was enrolled as an advocate in the month of December 1981 at Gujarat and continued his practice as an advocate until February 1997. During this period, he practiced almost on all sides like civil, constitutional, revenue, etc. in various courts, tribunals and commissions. In March 1997, he was directly appointed as a judge of the City Civil and Sessions Court, Ahmedabad, by invitation. He was sent to the Honorable Supreme Court of India for classification of cases of the Supreme Court in the month of May 1997. In 2006, he was appointed as Registrar, Courts and Computers, Supreme Court of India on deputation. He was also appointed as Special Judge, CBI Court, Ahmedabad. He was appointed as member of the Standing Committee of the Supreme Court of India for monitoring E-Committee for computerization of the entire judiciary in the country, and he developed the E-Court for the first time in India. He was elevated as Additional Judge, Gujarat High Court in November 2012 and confirmed as Permanent Judge in July 2014. As the Judge of High Court of Gujarat, he dealt with almost all subjects and delivered approximately 19,832 judgments in 1,260 days. Once again, I welcome you, sir. I request all our participants to keep their videos and audios on mute, and you can put up your queries and questions in the chat box, which will be answered at the end of the session by our guest speaker. So without wasting much time, let's start with this webinar now. Over to you, sir.
Thank you, Nancy, for calling me and to deliver a lecture on such a subject which is concerning everyone in the nation or in the world on day-to-day basis. Before I start it, I would like to confirm how much time I have to continue up to. Am I audible?
Yes, sir. You can take around 1 hour.
Okay. Okay. So because before that, I would start that question and answer. So, good afternoon to all of you. Just a second, I have to before we start with the subject, I would like to show you some slides which is concerning our day-to-day life. Just 1 second, because at last moment myself. Never underestimate your competitor. Expect the unexpected. Think there must be a better way. We cannot direct the wind, but we can adjust our sails. React now, because time, tide, and opportunity waits for none. If you want happiness for a lifetime, learn to love what you do. One man makes difference. You may be that one man in future, so don't bother for anything else. Best way to make your dream come true is to wake up. We have to work hard. For the subject, before entering to the main subject of criminal trial, we must understand that civilized society, the government, the legislature, the judiciary, and the media have to perform their role each in their own areas of competence and in a concerned manner for the judicial process to be speedy and effective. Law by itself may not be enough. Law is only an instrument. It must be effectively used. This effective use depends as much as on a supportive judiciary as on the social will to change. Active technological reform movement, if accompanied by properly enforced legal reform, can transform society. Effective technological reform movement does need the help of law and a sympathetic judiciary to achieve its objectives. When we are talking about criminal trial, let us realize what is crime. Generally speaking, taking or attempting to take or doing or attempting to do any act by means or process which is not accepted by the norms of the society or infringement of any legal provision may be termed as crime. It may be violent, may be silent, or it may be complained of or even may not be complained of by the sufferer. So the basic point or issue here is something which is norms which is not accepted by society, and infringement of any legal provision is called crime, and the criminal trial would deal with such criminals. So what is essential for to be a crime or to be dealt with by judicial system? There must be some statutory provisions precisely defining crime. There must be some punishment provided by the statute, and there must be procedure provided for the trial. So when we are talking about criminal trial, before coming to trial, this basic information is very much important and necessary. Crime is generally voluntary and willful act or omission or conduct violating existing law, and criminal trial is an aim to sentence culprits for adversely affecting body or property, and when something of secure environment is targeted by such criminals. These are the staircase of the criminal trial. Right from collection of facts, during police investigation, police will collect the facts, police will make it in time sequencing that what is what. Then police will shift the opinions and come to some conclusion by marshalling of facts. When it is presented before the court in the form of charge sheet, court has to find out the problem, the charge, and what is the main problem, what charge is to be framed. Then recording of evidence, churning of evidence by the court, shifting of evidence, weighing of different alternatives, whether there is a scope of presumption of particular thing or exception in law, then applying precedents, looking for probabilities, then finding and conclusion, and final order. So these steps, this staircase, right from A to N, shifts the ignorance to prima facie proof, then charge, then evidence, and then knowledge in the form of a judgment. That yes, somebody has committed a crime and he is convicted. But this entire process is a typical and technical thing so far as criminal jurisprudence is concerned. And therefore, I have drafted this staircase to find out or to realize that what steps are required to be performed or to be climbed during this criminal trial. In between, we would like to lighten you because subject is so critical, and if you light a lamp for somebody, it will also brighten your path. Cultivate hope. Neither fire nor wind, neither birth nor death can erase our good deeds. Then again, we'll come to the actual details of criminal trial. There is a long I have tried to make it in a presentation form in a PPT. We'll go through those slides, and there is list of other laws, criminal laws. There is list of criminal laws also. Is it visible?
No, sir, we can see the first slide only, the
Oh.
posture of the event.
This PDF is not visible, no?
No, sir.
Okay. We'll continue on slide only then. So there are so many criminal laws. The list is there. There may be some more laws in future. But so far as this criminal trial subject is concerned, I have tried to include following subjects: criminal trial, preface, what is crime, purpose of criminal trial, the steps of criminal proceeding, relevant laws, terminology, commencement of criminal process, right of accused to defend himself, fair investigation, fair trial, equal justice and free legal aid, presumption of innocence of an accused, burden of proof beyond reasonable doubt, trial is for discovery of truth, circumstantial evidence, public prosecutor, program or scheduling of trial, further investigation, further statement of the accused, role of appellate court, trial under Negotiable Instrument Act, victimology. There may be some more subjects, some more details may be there, but I have tried to prepare a note on all the above subjects. We'll try to cover as many as we can cover in this 40-45 minutes. Thereafter, we'll stop for answering your questions. In so many facts which I disclose here, the language is typical because those language are taken or those sentences are taken directly from particular judgments. Because ultimately, interpretation of law in our jurisprudence is based upon the judgments of High Courts and Supreme Court. Otherwise, text of statute is very well there, but I generally say to everyone in this field that real dispute in our society is what is said by X for what purpose and what is heard by Y in his own thoughts is the real dispute of all the problem or is real problem of all the dispute. This is the only dispute that what is said we do not understand that why it is said, but many a times we catch it that how it is said. Therefore, by understanding criminal law or any law in India, it is always better to follow the text or judgment of the High Court or Supreme Court only, instead of following our personal thoughts or anything else. I have tried to explain the subjects with reference to citations also, so that in future you may get those facts from those judgments. In the case of Jagbir Singh, Supreme Court has said, it is a nice wordings. A criminal trial is not like a fairy tale, wherein one is free to give flight to imagination and fantasy. It concerns itself with the question as to whether the accused arraigned at the trial is guilty of the crime for which he is charged. Crime is an event in real life and is the product of interplay of different human emotions. In arriving at the conclusion about the guilt of the accused charged with the commission of crime, the court has to judge the evidence by the yardstick of probabilities, its strict words, and the animus of witnesses. Unfortunately, unless we study the law and go to the court, we do not know what is criminal trial and how it is to be conducted. And unfortunately, in media, more particularly in cinemas, movies, it is shown in a different way. The way in which the writer or producer thinks it fit. But therefore, Supreme Court has said it is not a fairy tale, but it is a interplay of different human emotions, and judging the evidence by yardstick of probabilities by the court to find out the truth. Every case in the final analysis would have to depend upon its own facts. Although the benefit of every reasonable doubt should be given to the accused, at the same time, the court should not reject evidence which is ex facie trustworthy on grounds which are fanciful or in the nature of conjectures. The criminal trial cannot be equated with a mock sense from a stunt film. The legal trial is conducted to ascertain the guilt or innocence of the accused arraigned. The hyper-technicalities or figment of imagination should not be allowed to divest the court of its responsibility of and weighing the evidence to arrive at the conclusion regarding the existence or otherwise of a particular circumstances, keeping in view the peculiar facts of each case, the social position of the victim and the accused, the larger interest of the society, particularly the law and order problem and degrading values of life inherent in the prevalent system. The realities of life have to be kept in mind while appreciating the evidence for arriving at the truth. So by and large, during criminal trial, the court has to find out the truth and nothing but the truth. The courts are not obliged to make efforts either to give latitude to the prosecution or loosely construed law. The traditional dogmatic hyper-technical approach has to be replaced by a rational, realistic, and genuine approach for administering justice in a criminal trial. Criminal jurisprudence cannot be considered to be a utopian thought, but have to be considered as part and parcel of human civilization and the realities of life. The courts cannot ignore the erosion in values of life, which are a common feature of the present system. Such erosions cannot be given a bonus in favor of those who are guilty of polluting society and mankind. In the case of Monica Kumar, the Supreme Court has said, India has a highly developed criminal jurisprudence and prosecution system supported by judicial precedents. However, there may be certain issues or concerns relating to the execution of the same by police and implementation by judiciary. The courts in India, particularly High Courts and Supreme Court, have been proactively guarding the rights of the accused. Section 482 of CRPC explains the inherent powers of Supreme Court and High Courts, which includes power to quash FIR, investigation, or any criminal proceedings. Such powers can be exercised to secure ends of justice, to prevent abuse of process of any court, and to make such orders as may be necessary to give effect to any order under the Code of Criminal Procedure Code, depending upon the facts of a given case. Before reading further slides, let me explain it that when we are talking about criminal trial, by and large, everyone is feared or have a fear about criminal case being filed against him or police investigation being started against him. Society in large is generally afraid of police and investigating agency because though they may be performing their job, there is every possibility that some innocent may be charged or harassed for one or another reason by the investigating agencies. Therefore, there is a provision in Criminal Procedure Code by way of Section 482, which empowers the Supreme Court and High Court to cause, that means to stop the investigation or further investigation of FIR and criminal proceeding. So This is very important provision and facility available to Indian citizens, that if you feel that any criminal proceeding or trial is unnecessarily continue against you, or the investigation by police is unnecessarily harassing you, one can challenge such investigation or trial directly before the High Court or Supreme Court as provided under Section 482 of the Criminal Procedure Code. Court can always take note of any miscarriage of justice and prevent the same by exercising its power under Section 482 of CRPC. These powers are neither limited nor curtailed by any other provisions of the code. However, such inherent powers are to be exercised sparingly and with caution. It has to be exercised sparingly, carefully, and with caution, and only when such exercise is justified by the test specifically laid down in the section itself. So it is not simple that you file an application and proceedings would be stopped or quashed. But you have a chance to pause or to stop the proceeding or investigation against you if you feel that it is, or if it is certainly or perfectly it is not warranted. Powers under Section 482 of CRPC is to be exercised ex debito justice to do real and substantial justice, for the administration of which alone court exists. Even Article 21 of the Constitution of India has been interpreted in a highly dynamic manner to protect the rights, life, and liberty of the citizens by also incorporating the principles of natural justice. And let us examine what is the purpose of criminal trial. So many judgments are there, but most relevant and material judgments are of Anokilal, Zahira Habibullah, and Abdul Nazar Madan by Supreme Court of India. Citations are on your screen, but if you are a law student, I would prefer you to search it from available resources or legal databases, so that while searching one judgment, you may go through some other judgments also, and that is the art of searching or learning law. A criminal trial is designed to resolve accusations against a person accused of a crime. In most common law systems, criminals are entitled to a trial held before the competent court. So in general, no one can be punished without a trial. There must be a trial before competent court to find out that whether he is guilty or not. A criminal trial is a judicial examination of the issues in the case, and its purpose is to arrive at a judgment on an issue based upon fact or relevant facts, which may lead to the discovery of the factual issue by obtaining proof of such facts, at which the prosecution and the accused has arrived by their pleadings and evidence, but the controlling question being the guilt or innocence of the accused. So to find out that whether accused is guilty or innocent, both sides is permitted to adduce evidence before the court. Court will judge that evidence, appreciate that evidence, and will come to a conclusion that whether accused is guilty or not. And for doing this, if it is a civil matter, the word issue is being used, but if it is a criminal trial or criminal matter, the word charge is used. Somebody is charged with specific allegations, and whether that charge is proved or not is the ultimate aim of a criminal trial. Since the object is to mete out justice and to convict the guilty and to protect the innocent, the trial should be a search for the truth and not about over technicalities, and must be conducted under such rules as will protect the innocent and punish the guilty. The proof of charge, which has to be beyond reasonable doubt, must depend upon judicial evaluation of the totality of the evidence, oral and circumstantial, and not by an isolated scrutiny. The purpose of criminal trial is to dispense fair and impartial justice uninfluenced by extraneous considerations. So it is a pious duty of the court as well as pious duties of the police prosecutor to produce and to prove the fact before the court only. The steps of criminal proceedings. First is a complaint. Victim or someone may disclose the complaint to public record, which is called FIR, as provided under section 2 small d of the Criminal Procedure Code. When we say victim or someone else, means it is not necessary that FIR is to be lodged by the person who is victim of the incident or the crime. But in given cases, there may be a restriction that who can file a complaint. Like a complaint of bigamy, means performing second marriage, having a spouse already. If husband or wife marries second time, having their legal spouse, it's an offense under IPC, but for that, complaint can be filed by the victim only, not by anybody else. But otherwise, in most of the cases, anybody can disclose the commission of an offense to the police authority, and it is that disclosure, when registered as a complaint, is called an FIR, First Information Report. Then comes the second stage, most important stage of the criminal jurisprudence, inquiry. Inquiry by police, or it is called investigating agency, which may be local police, CBI, CID, ED, or different custom department, or whatever the offense. It depends upon the nature of offense. Whether crime is committed and involvement of person, including culprit who would be accused, and rest would be witness. Thereby, police investigation would decide or would determine that who has committed crime. But after that decision, after that inquiry, police department cannot punish the guilty person. The only thing, they can arrest them, but after arrest also they have to brought it to before the culprit before the court within 24 hours. So confinement, though confinement is managed by the police is not final authority. Police has to simply inquire the crime. During inquiry investigation, police will record statement of witnesses, and when it is clear during investigation before the police that particular person has committed any offense, police may arrest him or them and produce it before the court. So this inquiry is most material part of criminal jurisprudence. If there is no proper inquiry, culprit may be released by the court, or if there is improper inquiry, but not only improper, but colorful inquiry just to harass somebody, then some innocent may be punished for no fault on his part. During this inquiry, there comes the question of arrest. An arrest is initial stage in the criminal process in which an individual accused of crime is taken into police custody, in a custody. Majority of us are aware about arrest. Police arrest somebody, and unless court release him on bail, he or she or they have to remain in either in a police custody or in a jail, which is called arrest. Then comes investigation, which is part of inquiry. It will be a continued part of inquiry, but arrest would be there during inquiry or investigation. Collection of evidence regarding commission of crime. Police will collect evidence, or investigating agency will collect evidence regarding commission of crime. Once evidence is collected, police will submit a report to the court, which is called charge sheet. Charge sheet means submitting case before the court based upon inquiry and investigation. In case of absence of evidence or accused, see, in given cases like a theft, in almost many of the theft cases, accused is not found. In many cases like accident, evidence is not found. If there is hit and run, vehicle has run away, so who has committed offense, that evidence is not there. Accused is also not there. So in that case, police will file a report, which is called a summary, either to close or to continue the investigation. But when there is a availability of accused and evidence before the police investigating agency, they will file a charge sheet. And then filing a charge sheet means starting a criminal case against a person, the accused. Then first step before the court on receipt of charge sheet would be to frame a charge, to decide or to make a point that what is to be proved by the prosecuting agency in this case, or in other words, accused is brought before the court for commission of which type of crime, and thereby criminal accused would be called upon to prove himself innocent from commission of that crime. So framing a charge is very much important. If charge is framed under section 302 of murder, then there may be a lesser punishment for attempt to murder or something, but before that, charge is required to be changed, altered. Let's see, now once there is no evidence of murder, but we have tried to commit a murder, you may be tried for 307 also, section 307 of the IPC. So actual accusation by court seeking reply from the accused that whether he admits the guilt or not, or pleading not guilty, means that you say you didn't do the crime, or that he had a reasonable excuse for doing so. The court will then have a trial to decide whether he did it or not. This means if there is evidence that person has committed crime, he would be convicted, and the court will decide what sentence is to be given. All these details are provided in different sections of the CRPC. Those sections are shown with the text on screen. You can also refer CRPC. Then comes trial. Actual trial. Actual trial means recording of evidence by prosecution. During the trial, lawyers present evidence through witness who testify about what they saw or know. Then other side would cross-examine the witness. And after all the evidence is presented, the lawyers give their closing arguments. This is the crucial part of criminal trial. My experience, both as an advocate and as a judge, is a little bit different, because conceptually and principally, though everything seems to be very clear in books or in words, in practice, day in and day out, the difficulty is, though there is a disclosure of crime, though there is a disclosure of suspect who committed the crime, with due respect, I'm not blaming any agency, but unfortunately, many inquiry is in such a fashion that there is no proper evidence to prove the guilt or commission of crime by a particular person. Thereafter, when witnesses are coming to the court, when depositions were recorded in English only, not in vernacular language, one sentence is to be recorded by court. The witness will come in witness box and will say, I saw nothing, I know nothing. मैंने कुछ देखा नहीं, मुझे कुछ पता नहीं. What court can do? But many a times witness is telling truth because police statements of that witness is not recorded as per his story or in his word, but it is a cyclostyle of what is disclosed in FIR. So when a witness says that police has not recorded my statement, many a times he is telling the truth. When he says that I have seen nothing, I know nothing, many a times it is fact. But police has recorded the name of the person and his statement without asking me any few questions. And then this position happens. But if witnesses are perfectly depositing or making a statement or note before the court regarding nature of crime and involvement of victim and the criminal who has committed crime, it would be very hard for the criminal to escape from sentence and conviction and sentence, and probably no court will give them any benefit. But before convicting or sentencing the accused, there is a stage of further statement, FS, which is generally called in short as FS. It is a statement of accused. After evidence is recorded of all the witnesses against the accused, it is the duty of the court to read out the material part of those evidence, which either proves something against the accused or alleging something against the accused, and to ask him that about his explanation, if he want to say anything about those allegations or those facts which goes against him, which may goes against him. Thereafter, a stage of verdict would come. It is court's business to scrutinize and appreciate the entire evidence laid before it, all type of evidence. We'll discuss it in few lines of slides here in after. Oral evidence in the form of deposition testimony of the witnesses, scientific evidence in the form of postmortem note, injury certificate, report of FSL, or similar other scientific or technical reports. And in some cases, physical evidence like weapons used in the crime or any such other physical evidence. After appreciating all such evidence, court will deliver a verdict whether he is holding the accused guilty or not. If accused is held innocent, he would be free. Trial comes to an end. But if court find the accused guilty for committing the crime for which he was charged or charged, then again court has to hear him for sentencing. And after hearing the accused, court will pass an order of that how much sentence is to be imposed upon the person or the criminal, the accused. In our jurisprudence, the conviction and sentence by first trial court, either it may be a court of judicial magistrate in offences for which punishment would be less than 7 years, or by the sessions court wherein punishment or conviction would be sentence would be more than 7 years. There is a provision to prefer an appeal. Judgment of JMFC, order of conviction by JMFC can be challenged before the sessions court in an appeal, whereas order of conviction and sentencing by the sessions court can be challenged before the High Court in a criminal appeal if person is convicted. For criminal trial, whatever I have discussed till this point, there are few statute enactments India has a well-established statutory, administrative, and judicial framework for criminal trials. Indian penal laws are preliminarily governed by 3 acts: the Code of Criminal Procedure, the Indian Penal Code, and the Indian Evidence Act. To conduct a trial, one must go through all this statute properly and without fail. If you do not have a proper knowledge of any of this statute, your performance either as a judge or as an advocate in a criminal trial would not be up to the mark. So this is more important to go through all this statute. The procedure for a criminal trial in India is preliminary, except as otherwise provided, governed by the Code of Criminal Procedure, CRPC in short, which is a comprehensive and exhaustive procedural law for conducting a criminal trial in India, including the manner for collection of evidence, examination of witness, interrogation of accused, arrest, safeguard, and procedure to be adopted by police and courts, bail, process of criminal trial, method of conviction, and the right of accused for the fair trial. All these subjects, some provisions are there for all these subjects in the Criminal Procedure Code. Whereas Indian Penal Code, IPC in short, is primary penal law of India, which is applicable to all offences except as may be provided under any other law in India. Some offences are provided in other law, but majority offences, provision for majority offences are provided under IPC in IPC. The Indian Evidence Act is a detailed treaty on the law of evidence, which can be tendered in trial, manner of production of evidence in trial, and the evidentiary value which can be attached to such evidence. Evidence Act also deals with the judicial presumptions, expert and scientific evidence. There are certain other laws which have been enacted to deal with criminality in special circumstances. When we are talking about Evidence Act, and when there is a reference of presumptions, majority of you must be aware, or you must recollect it, that in some law there are provisions that particular fact is to be presumed even without proper evidence for that. One of such simple example is in under Negotiable Instrument Act, that holder in check, in due course, it is presumed the check is given by the person who has signed it to the person who is holding it for making the payment as disclosed in the check. This is because of the number of cases being filed before decades together in courts for recovery of money dues during civil transactions, civil commercial business transactions. To cut short those type of civil cases, there is an amendment in Negotiable Instrument Act, a civil law, wherein a bouncing of check, a dishonor of check was disclosed or declared as a crime, punishment. And now, unfortunately, you will be surprised to note it, when almost 25% or more than 25% cases in the courts are under Negotiable Instrument Act. Single subject, 1/4, 25% pending cases are only under Negotiable Instrument Act. Though there is presumption, but under the Act, to consider certain things in particular manner, judiciary is not capable to cope up with it because of the flood of cases under Negotiable Instrument Act, which is made a criminal offense by amendment before few decades only. Therefore, in beginning, I have conveyed you that law is norms of society or for which there is a statute. Otherwise, bouncing of check was a civil dispute before 3-4 decades. But after amendment in Negotiable Instrument Act, it becomes a criminal offense. It is also important to know that India follows the adversarial system where generally the onus of proof is on the state prosecution to prove the case against the accused. And until and unless the allegation against the accused is proved beyond reasonable doubt, the accused is presumed to be innocent. In certain exceptional cases which may relate to terrorism, etc., the onus of proof has been put on the accused person who claims to be not guilty. This is also second important point or issue to be considered and to be realized when we are talking about criminal trial or criminal jurisprudence. Onus of proof. Onus means duty. Who has to prove something? In Indian jurisprudence, it is the state's duty of the prosecuting agency, the complainant, to prove the case against the accused. And unless and until allegation against the accused is proved beyond a reasonable doubt, the accused is presumed to be innocent. Though this principle is well said, hard reality is otherwise different. As soon as accused is arrested, the presumption is against him that he has committed crime and he would not get bail. He would be sent behind the bars till trial is over. And after trial is over, if prosecuting agency could not prove the offense or crime against him, he would be released. But then there is no provision for compensating him for the period for which he was kept behind the bar for no fault on his part. This is the area where some development, some amendment, some thoughts are very much necessary. Both these things goes differently, but it is part of our society or our system and nobody bothers for it. Then let us examine some terminology in criminal trial before we discuss the issues or details of criminal trial. It is almost 40-45 minutes. Let us complete whatever we can. To appreciate the process of Indian criminal law, it is necessary to understand the following important terminology. FIR means First Information Report is formal recorded complaint by police in a case of commission of a cognizable offense and can be considered as a first step in the process of investigation of a cognizable offense by police. Section 154 defines as to what amounts to FIR. Bailable offense means an offense which has been categorized as bailable, and in case of such offense, bail can be claimed subject to fulfillment of certain conditions as a matter of right under Section 436 of the CRPC. In case of bailable offense, the police is authorized to give bail to the accused at the time of arrest or detention. Means for bailable offense, person is not required to be brought to the magistrate for bail. Police itself can release the person on bail. Like an accused of motor vehicle accident, 279 of IPC. Police can release the person on bail. He is not required to be brought to the court. But if there is a murder or any other heinous crime or some other crime, police cannot release a person on bail, and those instances or those offenses are called non-bailable offenses. Means an offense in which the bail cannot be granted as a matter of right, except on the orders of the competent court. In such cases, the accused can apply for grant of bail under Section 437 and 439 of CRPC. It is important to note that a grant of bail in a non-bailable offense is subject to judicial discretion of the court. and it has been mandated by the Supreme Court of India that bail and not jail should be the governing and guiding principle. But day in and day out, there are several accused, under trial accused who against whom crime is yet not proved. They are behind the bar, but in some cases, because of the nature of crime and their activities, it is must. But in many cases, keeping a person behind the bar for a long time without any reason is against natural justice. Cognizable offense cases has been defined under Section 2C of CRPC as an offense case in which a police officer can arrest an individual without a warrant. Non-cognizable offense has been defined under Section 2 of the CRPC as an offense in which a police officer has no authority to arrest without a warrant. So, in some cases, police can arrest you. In some cases, police needs a warrant from the court. Whether an offense is bailable or not bailable, cognizable or non-cognizable, has been qualified under the first table of the first schedule of CRPC, which relates to the offenses under IPC. The table second of the first schedule of CRPC gives a general guideline to determine whether an offense is cognizable or non-cognizable, bailable or non-bailable, and triable by court. The criteria in the table below is applicable in those cases which are silent on this aspect. This is a table. Offense punishable. This is a general guideline. When offense punishable with imprisonment is less than 3 years or with fine only, such offenses are non-cognizable and bailable, and it can be tried by any magistrate, like an offense of accident or traffic violation, like that. But some offenses where offense is punishable with imprisonment of 3 years and more, but not more than 7 years. Though they are cognizable offense, they are non-bailable. They can be tried by first-class magistrate, which means police can not release him on bail, but bail can be granted by the court only. But it may be tried by the first-class magistrate. In most of the cases in India, second-class magistrates are not there, but in MP or in some states there are some two types of magistrate, second-class and first-class. So this bifurcation of magistrate is with reference to period of imprisonment. But when period of imprisonment would be 7 years or more, including imprisonment for life and death, offenses are cognizable and non-bailable, and it would be tried by the Sessions Court. Bail can be granted by Sessions Court only. Almost 1 month, almost an hour is complete. I think let us stop here for question and answer, because if thereafter, if time permits, we will go further. And before starting question answer, let us again have some lighter mood. Provide shelter for others. Sign whatever the weather. Find a way or make one. And now question and answer. Let us take first question and answer because almost 1 hour is over. Then if I think during question and answer, we will discuss something, so it would take care of the subject. Yes?
Sure, sir. Thank you so much for such an informative webinar. It was a pleasure listening to you, sir. I request all the participants to please post their questions in the chat box. So, first question that we have received is from Mr. Aditya. He is asking, what is the difference between a judge and justice?
Yeah, generally the judge is up to a sessions judge, they are called judge. But High Court and Supreme Court judges, though they are judge, they are nomenclated as a justice because they have got a constitutional power to quash the FIR so far as criminal trial is concerned. Magistrate and sessions judge cannot quash the FIR. They have to continue with the trial. They can acquit the accused, but they cannot stop the trial. Whereas High Court and Supreme Court judge, because of their constitutional power, even stop the criminal investigation and trial, and therefore they are nomenclature, or they are having the prefix, or what you can say, something in their favor. It is called justice, but they are also judges. So basic difference between a judge and justice is all are judges, but High Court and Supreme Court judges are called justices. Yes.
Right, sir. Thank you so much, sir. The next question from Ms. Sonal is, if an accused of an offence is not found and the proceedings of Section 299 proceeds, but after some day we find the accused, then what is the procedure further for the accused?
See, in general, in any criminal trial or in any litigation, if somebody is not found or not available for trial or for proceeding, there is some different provision so far as criminal proceedings are concerned. First is to issue non-bailable warrant against him, and even thereafter, if he is not found, there would be his property would be seized and sold by the state authorities. Properties would be seized. But once a person is available before the court for trial, for the period for which he is not present, he may explain the reason for his absence. Court may consider that reason, may impose some cost of penalty, but the other provision for seizure of property and everything would not be in picture. It would not be action, and trial would be continued as if that period was lapsed. Means now person is available for trial. So once somebody appears, then everything would be in order. Yes.
Right, sir. Thank you so much, sir. The next question from Mr. Aditya is, so what is the role of police in criminal cases when police itself has caused an injury to a person who was innocent?
Very tricky and typical question, which I have already explained during my discussion. You are right, Aditya. If police has injured somebody during investigation, during inquiry, or otherwise, it is very difficult for a victim or a common man to get justice, because ultimately investigation is done by the police only. It's the same area police. In those cases, there are certain judgments and certain provisions, certain guidelines that victim can approach the court for transferring the investigation from that particular investigating police station or person to some independent police agency, and thereafter that policeman would be tried like a common man. So when police officer injured somebody, if that injury, causing of that injury was not part of his official duty, because sometimes if somebody, you must be seeing movies and cases of encounters wherein police fires against somebody and kill them. So there is also injury, but there is an exception that somebody accused was trying to flee away, and therefore we have beaten him. So if in those cases there may be something in favor of police, but otherwise victim can approach the court and can get an order for investigation by other independent police agency or other agency, and in that case the police officer who has injured somebody would be punished. And there are several cases of such punishment, which is generally known as police atrocity cases in a legal database. Police atrocity cases. Yes.
Thank you so much, sir. The next question from Ms. Sonal is, what are your views about new CRPC?
Oh, but what is new CRPC? Is there anything in picture? I do not follow what is new CRPC, but you can say new CRPC means there may be a need of so many amendment in CRPC, but there may be a different views. In my personal view, except controlling powers of police, the provisions of CRPC is well founded and it is taking care of innocent person. Yes.
Thank you, sir. The next question from Mr. Mohit is, if police arrested a person in bailable offence, then the person has the right to demand bail in front of police only, or he must approach court?
No. He can ask for a bail directly from the police in cases of bailable offences like motor accident case, traffic rules case. So in table I have shown where punishment is less than 2 years, 3 years, though, and when the offence is bailable, police has to release the person on bail, and it is to be asked to the police only. No, there is no need to approach the court. Yes.
Thank you, sir. The next question from an advocate is, if pharmaceutical drug API confiscated by a drug inspector is saying it's spurious after investigation. But sir, my client purchased all the drugs API via legal purchase order and bills. I have filed application under CRPC section 451 to release drugs API. Then how can we get release those confiscated drugs, hair drugs and Cosmetic Act 1940?
Mr. Sunil, it's a out of box question. It's a question regarding some pending trial. It would be difficult to answer it because my views may be different, some the court's view may be different, but you are seeking legal advice. Anyway, I will explain you in a general terms. The first thing is, according to me, you should not ask to release those goods unless it is proved that it is not spurious. So get it tested by appropriate laboratory and first get confirmation that it doesn't have any contraband, is any objected drug or material or chemical inside. Otherwise, it will never release in your favor. This is the first thing. The second thing, your application under 451 of CRPC will be taken care of by court as per the available evidence on record and as per the decisions by Supreme Court and other high courts. In that case, what is evidence before the court? There is an FIR or there is a report that drugs is having some contraband material. In that case, how court will release it in your favor? Therefore, I have said you in advance, in first step, that first of all, you should be clear that whether that material is having any contraband contents, any drug or not. Otherwise, no court will release it. Yes.
Thank you, sir. The next question from Mr. Parin is, my question is, during cognizable offence, if in spite of availability of evidences and witnesses of such an offence committed against a victim, if the police does not take immediate action just because of the offender is a person having a powerful authority, what are the provisions of actions which can be taken against the particular police officer?
Parin, before answering your question, I have noticed the second part of the previous question. That Advocate Sunil, you have said that you have received the goods from your supplier. In that case, you have to prove it before the court that you have simply worked as a supplier or a businessman and you have not manufactured it or you have not packed it. If packing is not done by you, if you have not manufactured it, then you can take that stand before the court. Now coming to the Parin's questions, during cognizable in spite of available evidence and evidence of such offence committed against something doesn't have in this case also, Mr. Parin, you have to approach the High Court for appropriate direction to the police or to change the investigating agency. But your question is right, is a much concern that in many cases where accused are powerful, police will be slow in performing their duties. But you must have seen the case of Likhipuri accident case in UP. A minister's son was also, after few days, because of High Court and Supreme Court's intervention, the son of a minister was arrested and taken behind the bar. So there is everything is nothing to be worried about. Everything is possible if you take proper steps and care. Yes.
Thank you, sir. The next question from Mr. Harshit is, if policemen don't cooperate well and are helping the opposition, then where can we complain against them?
I think answer is already there when I discuss Parin's questions, the same answer. Approach the court.
Right, sir. Thank you so much, sir. The next question from Mr. Aditya is, so how much comparison of powers are there between district judge and additional district judge?
So far as judicial powers are concerned, there is no difference. The only difference in the powers between district judge and additional district judge is administrative powers. District judge has some more administrative power within that court functioning. But at the time of appointment, in given case, powers for conviction of under 302 and other heinous crimes, capital punishment, those powers are not given or assigned on day one to additional judges. In some cases, not in all, but who are appointed directly from practice, from advocacy, the judges, the session judges who are directly appointed from bar, is advocate who is directly appointed as the session judge. In those cases, sometimes the powers of capital punishment are being released after some time. And otherwise, both have equal judicial powers. Yes.
Thank you, sir. The next question from Mr. Pratik is, if a case was discharged in disposal, so can it be go under revision in the same court? Can order be changed under revision after getting discharged from former court?
If a case was discharged in disposal, so can it be go under the revision? No. If somebody is discharged by one court, then that court has got no jurisdiction further to deal with that court. A person who is not happy with the order of discharge can file revision before the higher court. Thereby, if accused is discharged by JMFC, judicial magistrate, then revision would lie before the sessions court. But if accused is discharged by sessions court, revision would lie before the high court. Yes.
Thank you so much, sir. I think we have all the queries solved herein.
I think almost more than an hour has been passed. So
right, sir.
We have to stop here. My lecture is almost 1/3 only is completed, but it is the subject is such a lengthy that it is difficult to complete everything in an hour. Anyway, thank you to all of you.
Thank you so much, sir. It was really an informative and knowledgeable session with you today. I thank our participants also who have joined and taken out time from their busy schedule. Thank you so much, sir, once again.
Thank you. Thank you all of you.